So, Professor Disanayake, honored heads of department, ladies and gentlemen. Well, thank you so much for inviting me to this very special occasion. And thank you, Indira, for your very generous and extensive, perhaps too extensive, introduction of my background. It's a very special honor to be here because this is the keynote event, as it were, for the university, the major event for the university, and so many different faculties are involved in this particular event. And furthermore, it's very encouraging to note the important work being done by all the different faculties to help the people of Sri Lanka. In terms of the general themes, it seems to me the general themes of the different works of the faculties, have to do with development and human development and issues of governance. So I feel very privileged to be here and to be able to address you all on this occasion. On a slightly more personal note, I'm very happy to be here because my grandfather, B.C. Anghie, was the registrar of the University of Colombo. He was the registrar of the University of Colombo from about 1951 to 1955. This was at a time when his predecessor, Cecil Bellman, shifted to Peradeniya. My grandfather was the assistant registrar at that time. And so after Mr. Bellman passed to Peradeniya to help establish Peradeniya, my grandfather worked here for a few years. But perhaps he's better known for being a master at various schools, including St. Peter's and Royal, where he was involved with the rugby team there. And also a place called St. Joseph's Grand Pass. I don't know whether St. Joseph's Grand Pass still exists or not. It does, but that's where he began his career. So I'm very glad to be here, perhaps to some extent following in his footsteps as somebody who's also involved in this great profession of teaching. And I think we are all here very fortunate to be involved in this great profession of teaching, because it is something that is of such consequence, not only for the individuals concerned, our students, but also for the country more broadly. Let me then move to my topic, which has to do with this whole complex issue about sovereignty and governance and the three regimes that I mentioned here. I must say, at the time that I formulated this topic, which was many weeks ago, thanks to Sampath's kind invitation, I didn't realize that this topic of sovereignty would become so complex and fraught. And of course, we now find ourselves in a situation where this is very much a topic of general interest as a result of the United Nations Human Rights Council resolution, the release of the Paranagama Commission report, and so forth. I have to say that rather than talk about those particular reports and the findings of that particular commission, and it's difficult to do that because they've just come out, what I thought I would do, and perhaps this is what academics should do, is to try and step back and look at some of these fundamental concepts of sovereignty, not just in terms of the immediate issues confronting Sri Lanka, but in terms of the broader history of the development of this concept and how this concept has emerged in issues of international law and global governance. So that is my particular approach, but it is hard to overlook the fact that this is the 200th anniversary of an event which is regarded as the event which represented the loss of Sri Lanka's sovereignty after something like 2,500 years, and that, of course, is the Kandyan Convention of 1815. And I was reminded of this when coming on my very long flight from the United States. I saw a film called something like Ahalipole Kumarahamige. Yes. This was about the 1815 event. I wasn't sure from the film, I think it starred Jackson Anthony. I wasn't sure whether he was Ahalipole or the king. Which was he? And the further issue that interested me was it was quite a complex issue because I wasn't sure who the hero of that film was. Now, of course, my problem is that I don't understand Sinhalese properly, so I had to rely on the translation. But it seemed to present a fairly complex issue about who was the good person and the bad person. And perhaps the larger moral is that there wasn't really a hero as such. Perhaps the hero is Ahalipole Kumarahamini. She is the woman who is trying to look after her children and her family in these very difficult circumstances, which makes her fate all the more tragic. So it's interesting to think about this concept of sovereignty. Where does it come from? What does it mean? So I have to ask for your indulgence here, because I'm going to talk to some extent about my own discipline, that is international law. But I hope it is of general interest, because what I find has happened over the years is that the specialized subject of international law has become a topic which is becoming increasingly relevant to public debates and to everyday conversation almost. I'm very grateful to the University of Colombo, which has always been, and the Faculty of Law at the University of Colombo, which has been so hospitably inviting me to speak about human rights issues and on international law issues. And I remember when I talked about human rights issues and the responsibility to protect, say in 2004, 2005, nobody took any interest in it. Responsibility to protect was seen as some distant abstract concept. And then over time, this concept became an issue of central concern to the general public of Sri Lanka. So it's very interesting how concepts of international law have become issues that are of general concern. And so it is in that light, without becoming, I hope, too technical, that I will be talking about issues of governance and sovereignty and international law. So, sovereignty, where does it come from? Well, in international law, the argument is that sovereignty was created by an event that took place in Germany in 1648, and that was the Peace of Westphalia. So the basic idea of sovereignty, and I'm simplifying a great deal, is the idea that a particular government has complete power over what happens within its own territory. So that is what Westphalian sovereignty is taken to mean. Now, the interesting thing is, if we actually look at the history of Westphalian sovereignty, we will find that the issue of minority protection has always been a concern of international law. The protection of minorities has always been a subject that is an issue of international concern rather than of purely domestic concern. And we can see this if we actually study the Treaty of Westphalia in some detail. Why was this the case? It was because there were religious minorities within the states that had been established by the Treaty of Westphalia. And some sort of protection had to be provided to those minorities in order to make sure that religious conflicts would not flare up yet again. However, over time, the concept of sovereignty changed. But the interesting issue to note here is that the concept of sovereignty we are talking about is essentially a Western concept. That is what Sri Lanka is trying to defend now, an inherently Western concept, because it comes from the Treaty of Westphalia. Indigenous ideas of sovereignty were very different. If we have a look at the work of anthropologists working on, for example, Thailand and Siam. There's some wonderful work done about this. There's a book called Siam Mapped. And there, one of the issues that was pointed out was that the Thai concept of sovereignty was very different from the Western concept of sovereignty. So that's the first thing I want to point out here. When we talk about sovereignty in the modern sense, we are talking about Western sovereignty, and that is what we are trying to defend in these particular circumstances. Now, having said that about sovereignty, the broader concept I want to discuss is the issue of governance. So I'm not talking here about international government, I am talking about international governance. Let me try and distinguish between those two concepts. So when we talk about international government, the simple fact is that no such thing exists. We do have the United Nations, but the powers of the United Nations are limited and they do not extend to every activity that is relevant to international affairs. By the term governance, I refer to what are in many cases informal systems of regulation which govern the many different actors whose behavior affects international relations. So of course, states are the classic actors of international law, but in the globalized world in which we live, we understand that there are so many different actors who exercise considerable power when it comes to international affairs. So we can think about international organizations, the United Nations, for instance. We can also think of corporations. So it's interesting to note that the most powerful multinational corporations have economies which are, you could say, more wealthy than many countries. And we're getting to a point now where certain individuals themselves are so wealthy that they would have more economic resources available to them than actual countries might have available to them. if we compare something like Bill Gates and Microsoft and some of the smaller countries in the South Pacific, the economic resources of an individual exceed the economic resources of a sovereign country. So the question is, we have these multiple actors, non-governmental organizations as well. The interesting question is, what are the regulations which are non-legal that still govern their behavior? Perhaps another way of trying to make this point, the difference between government and governance, is to think about the trishaws which line up outside the Cinnamon Grand. One thing that has interested me is who gets to line up there in that particular queue. Now, of course, I'm sure there are municipal regulations and so forth which would have rules about tuk-tuk drivers and who should have the capacity to line up in particular places. But from the rough and imperfect research I've done on this issue, and this might be a subject of empirical research, it turns out there's a complex system among the different trishaw drivers about who has priority and who can transfer their rights to a position in that taxi queue to other people. So then I have to ask myself the question, well, what happens if there's a dispute? To whom do you go to resolve this dispute about who should occupy a position in that taxi queue? And it seems there's quite an interesting and complex system in place. Now, none of this has to do with the law. It is not a legal structure. It is an informal structure which is actually perhaps more powerful than the law. Can we see the complication? So that's the difference between government, that which is prescribed by law, and governance, which is informal systems of rule that are still very powerful. So I hope I've made that distinction between government and governance clear. It is in this context that I want to talk about the issue of indicators. So the three regimes I mentioned in my paper are the regimes created by indicators, the regimes created by human rights, and the regimes created by foreign investment. Those are the three regimes. I'm not talking about Sri Lankan regimes such as Mr. Rajapaksa's regime versus Mrs. Kumaratunga's regime versus the current Yahalpania. So let me make that quite clear from the outset. Indicators. So this, I hope, is a topic that might be of general interest because what we find now is a system where indicators are creating systems of governance. Not government, but governance. Indicators have no legal status. And yet my claim is that indicators can be extraordinarily powerful in shaping the behavior of institutions, of individuals, and even of states. So what is an indicator? So let me give you a technical definition, which I will then try to unpack. So my colleagues, Benedict Kingsbury, who teaches with me at the University of Utah, who's done pioneering work in this field, together with his colleagues, Sally Engel-Merry, who is an anthropologist. So this is an area where, as Professor pointed out, as Professor Dissanayake pointed out, interdisciplinary approaches are useful because the law has an effect, not just because it is the law, but because of the way in which it affects society. And that is something that sociologists or anthropologists would be able to provide insight about. So my colleagues are Professor Kingsbury, who teaches with me, and Professor Sally Engel-Merry, a prominent anthropologist, and Professor Kevin Davis, who's a business law specialist. So they define an indicator as a named collection of rank-ordered data that purports to represent the past or projected performance of different units. That's a bit technical. But we're all familiar with indicators because, in fact, I would suggest that we ourselves use indicators all the time. And indicators seem to be very useful to us because they aggregate or collect a huge amount of very complex information, and then they provide a particular index. And then they provide not just an index, but also a ranking. And so some of the indicators that we might all be familiar with are the World Bank, the ease of doing business indicator. Now that, I would suggest, is very important for many countries which are seeking to attract investment. Because one thing that the investor would look at is, well, what is the business environment like in this particular country, and how can we easily assess that? So we have the World Bank Ease of Doing Business indicator. We have Transparency International, purporting to measure corruption in different countries. Most recently, I didn't keep track of the Financial Times in Sri Lanka, but I felt that if I kept track of the Financial Times in Sri Lanka for 2 weeks, I would be able to provide you with like 10 different indicators because they continuously refer to indicators when assessing various issues. So one indicator that I came across in the Financial Times said something like, Colombo airport is the 10th worst in Asia in relation to your ability to sleep at that airport. And I haven't been to all the Asian airports, but I have to agree that it's not very easy to sleep in Sri Lanka, in the Colombo airport. And of course, as academics, we are now at a stage where we cannot escape indicators. So it is very interesting to note that when the Times Higher Education Supplement recently released its list of the world's best universities, I checked the newspapers of different countries, and that story made an impact in the news in Singapore. It made an impact on the news in England. It made an impact on the news in Australia. All these different newspapers look at the Times Higher Education Supplement ranking of world universities. And Singapore is particularly proud of their achievement, because now Singapore, NUS, is the best university in Asia, at least according to the Times Higher Education Supplement. And they're very proud of that achievement because they've been trying hard to overtake the University of Tokyo, which previously occupied that position. And I believe I saw that Sri Lankan universities are also ranked in these particular indexes. So of course, we find these things ourselves particularly useful at a personal level. I mean, many of us would use TripAdvisor. So TripAdvisor purports to rank the best restaurants in Colombo or the best places to have pizza in Colombo or whatever it is. And of course, the interesting thing about these indicators is that we ourselves participate in the making of these indicators, because you can write a review of a particular place, and that is going to have an impact upon how that place is regarded. So indicators are necessary and helpful. And I looked at some of the papers that are being presented at the various research fora. And I noticed, for example, that we do need indicators to try and assess whether there's an improvement of the teaching of English in Sri Lanka, for instance. So all that requires indicators in one way or another. Now, why do I see this as an element of global governance? And I've already suggested one of the reasons for this. It is because these indicators could be even more powerful than international law in affecting the behavior of different actors. So now, I don't know in Sri Lanka how seriously different institutions in Sri Lanka treat these indicators. At this stage in the research about indicators, I would say that we're at a point where the main issue is trying to understand how indicators are created and trying to understand, for example, the economic impacts of indicators. So, for example, we have indicators for corporate social responsibility. And the interesting question is, what would happen to a corporation if it drops in the rankings in relation to corporate social responsibility? I do know that in academia, in some universities, we've found that indicators are now pretty much inescapable. And I've been in a position to consider the applications for promotion and tenure of various scholars from around the world, and I find more and more indicators being included in those applications. So for example, it's a question of how many citations does a particular scholar have? And in addition to that, there are all these indices which I don't understand. So there's an H score and an I score, and then there's Google Scholar creating all these masses of information which have a huge impact upon the way in which the university is perceived and the way in which the scholars are perceived. Now, initially at my university, the University of Utah, we thought this whole issue of indicators is nonsense, because if we look at indicators carefully, very often they are highly imperfect in actually measuring what they claim to measure. Nevertheless, we found that our students started asking us about our situation when we started to drop in our rankings. Because what the rankings do is that it changes our perception of who we are at a very profound level. So previously, we could see ourselves as being happy and self-satisfied in a particular context. And then we have some ranking which says, actually, you're not so good after all. You're only the 50th best, whatever it is. And of course, our students, lawyers, would be traveling all over the country, and they would be competing for jobs, and they would also be involved in litigation. And in these contexts, it's very easy for a law firm to say, well, we'll take a school that is ranked number 5 ahead of a student coming from a school ranked number 15. So can we see the issue about how indicators actually exercise an enormous amount of pressure? And they exercise a pressure through our own internalization of these indicators because they become a part of who we are professionally. I can imagine, I've been exchanging cards with several of you before, during the break, and I can imagine a time when somebody would present their card saying, so-and-so, professor, whatever it is, H score 12.6. I score whatever it is. We become our indicators, the indexers, and we are being continuously measured. So the question here is, what are the implications of this system of governance, a highly informal system of governance, for the exercise of power globally? So, as I said, I don't know in Sri Lanka how seriously the government would look at the question about a change in the status of Sri Lanka when it comes to the ease of doing business. I think Sri Lanka is ranked, so the World Bank Doing Business Index, Sri Lanka's rank in 2015 was 99. Which is an improvement of its rank in 2014, which is 105. It is not only governments, of course, and my suggestion is that we can't afford to ignore indicators, and that was the point of my story about what happened at the University of Utah. So I'm not sure whether governments can actually afford to say, well, we don't care what the indicators say when it comes to these issues. So this is something that I feel might be of interest from a research perspective, if that is something that is not already being done in Sri Lanka. And of course, it is not only governments that are so affected by indicators, it is corporations. Now, we have a number of corporations here, which it seems to me are trying very hard to make a reality of goals in relation to sustainability, for instance, and in relation to issues of social responsibility. So I think MAS Holdings and Jetwing Hotel, no, I'm not being paid by any of these people, but MAS Holdings, Jetwing Hotels, and the Heritage Group, they all do claim to promote sustainability in various ways. So if we're talking about relationships between business and the university, which is something that was mentioned, then I wonder whether this is something that it might be useful to try and look at in terms of questions of how the university can contribute to businesses doing better if indicators matter at all in relation to these issues. At least research the question of what does it mean to be dropped in the rankings or ascend in the rankings in these types of circumstances. Now let me turn to the more scholarly questions that we could ask. So I focused on the policy and practical questions, but the policy questions we could ask is, who creates these indicators? Because the indicators are not neutral. On one hand, you could say these indicators simply report facts. But it could be argued that the indicators create the facts that are already predetermined by the concepts that you use in an attempt to say that this is the concept you are measuring. Does that make sense? So you define a new concept, and then you create the indicators that you claim would be capable of measuring that particular concept. So I do believe that ideas are a source of enormous power. So the question then is, who creates these ideas? And the interesting point about many of these indicators is that they have a special status and authority because they are seen as a product, not of political factors. So when we criticize the United Nations, you could say it's all politics. But when it comes to indicators, the argument is indicators are not politically driven, they are driven by expertise because they are produced very often by institutions which claim to have superior knowledge and the most highly qualified people who've got PhDs from prestigious universities, according to the rankings, and who work for institutions such as the World Bank. The World Bank exercises power not just because of its actual financial might, but because of the ideas it creates. And it seeks legitimacy and authority for the ideas it creates by saying, we have all these experts working on these ideas. So in other words, indicators present themselves quite often as being objective and the production of experts rather than political and partial and biased. Can we see that other distinction that we would make here? I think the question that we should ask as scholars is, firstly, who makes these indicators? And of course, we all make indicators all the time, but there are some indicators which are extremely powerful. And for example, if we take a category, you create a category called the failed state index. The failed state index. This is introducing to international relations a concept that had not existed previously. And once you create this concept, then the issue is you've got to justify that in some semi-scientific way and provide a set of indicators by which you can measure whether a particular country is a completely failed state or a state on the verge to failure or a very successful state. Can we see the issue? This is what I mean when I say that the concept creates the facts and the categories. So all these things are exercises of power. They do affect the whole system of global governance. And the interesting question then is, how can these indicators and the people who create them be made more accountable? Because at least in a system of government, we are accustomed to the idea that whoever exercises the powers of government should be held accountable. Whoever exercises power should subject itself to ideas of transparency. So who does this in the case of indicators? So, and furthermore, we could ask another question, like the doing business indicator, what does that include and what does it not include? So there could be controversies, for example, about the doing business index or ease of doing business index, whether it takes into account or how it characterizes labor, how it characterizes employment issues. Because it might be the case that you would do better in the doing business index if you have looser protections of labor law. And I can see Nigel Hatch here. I should ask him about this in terms of some of these issues. So can we see that it's a very political concept, even though it presents itself as being neutral and objective? I just want to raise some of these issues because this is my attempt to fulfill the requirements in a way of this presentation, which is to talk about global developments and more regional developments to the extent that these discussions might be helpful for research here in Sri Lanka. The second area I want to talk about, the second regime, is a regime which is more controversial, or perhaps not, and that is the regime of human rights. And this is the subject of immense debate here. So the first thing we have to say about human rights is that human rights is indeed an intrusion of sovereignty if we understand sovereignty in strictly Westphalian terms. Because human rights says that the way in which a state treats its own citizens within its own territory is a legitimate subject matter for international concern. So the previous idea of Westphalian sovereignty was whatever you do to your own citizens in your own territory is something that is entirely your business. No other institution, no other country can interfere with what you do to your own people and within your own territory. We have to ask the question why human rights emerged, and that's a complex issue, and many histories are being written about human rights at this point of time. But it's clear that the experience of the Nazis and what the Nazis did to the Jews in Germany was a powerful animator of the whole human rights movement. It was seen as a disgrace for international law that despite the atrocities committed by the Nazis against the Jews, international law had nothing to say about that issue. Because the Nazis could claim, well, these people are our own citizens. You, other countries, have no right to interfere with how we treat our own citizens, even if what we do to our own citizens are extraordinarily atrocious acts. So that was the animating factor. Now, we might see human rights as being a purely Western creation. And at the time that human rights was created, there was a real concern about the extent to which human rights would actually interfere with issues of sovereignty. So in order to protect against that concern, the drafters of the UN Charter included in that charter Article 2.7. Article 2.7, which has been cited quite often, I think, by the Sri Lankan government and supporters of the Sri Lankan government, basically says that the United Nations cannot interfere with any issue that is inherently within the domestic jurisdiction of the state. The United Nations, and I can't find the quotation, you could say the, okay. Let me try to be scholarly, and let me try and cite you the actual language. The United Nations cannot interfere with issues, cannot interfere, and I quote, with matters which are inherently within the domestic jurisdiction of a state. So the interesting question is then, what matters are inherently within the domestic jurisdiction of a state? Now, it's in this context that we have to consider the attitudes of the developing countries in relation to these issues. And what is interesting is that the developing countries initially were extremely supportive of international human rights law, even though the claim was that human rights is Western in its origins. And I do believe that's a correct claim, by the way. I do believe human rights are Western in their origins. But developing countries actually supported human rights in a very powerful way. So, a very special and important event took place as far as non-aligned countries are concerned, or developing countries are concerned, in 1955. 1955 was the date of the Bandung Conference, the great conference, the first meeting of third world countries. What we also have to note is that the conference only took place because of another conference which was held in 1954, and which was the springboard, in a way, for the conference that took place in Bandung in 1955. And that conference that took place in 1954 took place in Colombo. It was a conference that was inspired by Sir John Kotelawala. So it's important that we understand our own history before we start talking about many of these issues. So this was a conference which was attended by Nehru, who was a champion of the third world, Sir John Kotelawala, of course, representatives from Pakistan and from Indonesia. And it was at that meeting in Sri Lanka in 1954 that the plans were first considered to have the Bandung Conference in 1955. So I think we should do some research on this, because this is a contribution that Sri Lanka has made, just like 1976 and the non-aligned movement conference that was held here. How many people remember that, or the importance of that particular event? So the interesting thing to notice is that at Bandung, the developing countries said, and I quote again from the Bandung communique, they issued their full support of the fundamental principles of human rights set forth in the Charter, and they took note of the Universal Declaration of Human Rights as a common standard of achievement for all peoples and nations. Why did developing countries support human rights so powerfully? They supported it precisely because they were trying to free themselves of colonial oppression. The colonial countries, the European countries, did not want to support the application of human rights to their own colonies, because that would constrain what they did within their own colonies. Can we see the issue? So it was in these circumstances that developing countries saw human rights as being an important vehicle, an important means of furthering the cause of third world peoples. The other interesting thing to note is I have already argued or pointed out the importance of Article 2.7 about non-interference. The countries which argued for an expansive reading of the powers of the United Nations were the developing countries. It was the developing countries that tried to defeat a reading of Article 2.7 that would prevent the application of human rights in different territories. Isn't this ironic? It is the developing countries which wanted to defeat the claim that human rights is actually controlled as or subordinate to sovereignty. Why did they do that? They did that because they were particularly concerned about what was happening in South Africa during the period of apartheid. So the United Nations was taking different measures against South Africa, principally through the General Assembly. And it was in that context that South Africa argued, you can't do this, United Nations, you can't do this, General Assembly, because if you do this, you will be violating Article 2.7 of the Charter. Can we see the issue? It was the developing countries who said that reading of 2.7, which prevents human rights from being asserted against authoritarian governments, that reading cannot be accepted. It is not in keeping with the aspirations of the United Nations. It was the developing countries which argued this particular case. Now, of course, things have changed since then. And the interesting thing to note is that once colonial tyrants were replaced by local rulers, the local rulers took a very different attitude towards human rights. They said, we don't need human rights anymore now that we have sovereignty. So the interesting question to ask is, what is the difference between colonial oppression or indigenous oppression? And of course, the very interesting thing is that the tragic thing was that many of the champions of independence became themselves tyrants in Asia and in Africa. Many of the great leaders of the nationalist movement themselves acquired power and then used their power to plunder the country as effectively as any colonial power had plundered that country. The interesting thing is that many of these third world dictators used precisely the same techniques that the colonial rulers had used. In many of these countries, you find a situation where there were, especially in Africa, you had a situation where there were many communities living in the same state. And in these countries, the third world dictators would try and play the race card. In other words, in many ways, use one community against another to further their own particular interests. And of course, that's a classical colonial tactic, divide and rule. So this was the paradox then that human rights confronted. Let me now then, having sketched that brief history, point to another phenomenon that I think would be helpful and useful here. And that is the recent emergence of what might be called regional systems of human rights. So we focused a lot about the United Nations because that is the institution which has had a lot of impact on Sri Lanka in recent times. But it's important to note that many countries felt that the creation of an enforceable system of human rights is very important. So the example I would give you here is the European Court of Human Rights. So under the European Court of Human Rights, any member of a minority who feels that his rights or her rights have been affected can make a claim not in the national courts, but in the regional system of the European Court of Human Rights. So it seems extraordinary that all the countries of Europe, pretty much, are willing to allow human rights claims to be made not within their own jurisdiction, but in this international system, which is the European Court of Human Rights. We could ask, why did they do this? Why were they prepared to sacrifice their sovereignty in this regard? And I think that's an open question, but one of the issues that they would have confronted is that in a situation where there is massive division among different communities, it might be difficult for a particular community to feel that their rights are being properly vindicated by a system of law or national system which could appear to be biased against them. Now, I'm not saying that it's always biased or necessarily biased. We are not saying that. The argument is that decisions would appear to be more legitimate and fair if those decisions are made not by the national courts, but by the system of the European Court of Human Rights. Now, the interesting thing to note is that the European Court of Human Rights system has applied even when these countries have been in a situation of ongoing conflict. So even during times of conflict and insurgency, the European Court of Human Rights has still been in operation. In fact, there are many cases dealing with this issue. There was a case that went before the European Court of Human Rights, for example, which had to do with the treatment of detainees by the government of England, the United Kingdom, in relation to the conflict taking place in Northern Ireland. So this particular individual said, I have been tortured by the United Kingdom, and I want my claim to be heard by the European Court of Human Rights. So even issues as complex and intimate to issues of sovereignty, such as the treatment of individuals in a time of conflict and war, those are issues that have gone up before the European Court of Human Rights. In a recent case, Anghie, the European Court of Human Rights went so far as to say that the European Convention also applies in a situation where the British are fighting in Afghanistan and in Iraq. So in these circumstances, you could say, well, human rights should only apply in the territory of the country which has signed the treaty. But in this case, the argument was, no, United Kingdom, you are operating in a foreign territory, but you have control over these individuals. And if you have control over these individuals, then you are responsible for the protection of their human rights. Can we see what an extension that is of the whole idea of human rights, where they apply beyond territory and is based instead on the issue of control. Now, there is controversy about these decisions, and there's another decision which goes the other way. But all I'm saying is that all I want to do is to point out the existence of the system. And it is not only in Europe that we have regional human rights systems. We have a regional human rights system in Africa. We have a regional human rights system in Latin America, the Inter-American Court of Human Rights. And it's interesting to note that in these contexts, the Inter-American Court of Human Rights has developed a fairly sophisticated jurisprudence about the rights of relatives to understand what has happened to their own kinfolk who have disappeared. So please, if you're interested in this issue, consider what the Inter-American Court of Human Rights is doing. Now, one of the reasons perhaps why regional courts are more effective than international courts is that there's a sense that these courts are created by states which have similar histories and similar cultural concerns. So that is why they might be more willing to cede their sovereignty, because they're not ceding their sovereignty to some distant organization. They are ceding their sovereignty to a regional organization which understands them in these important ways. Let me take the example of the African Union. It is extraordinary to note, I think, in terms of the issues of sovereignty, that Article 4 of the African Union says in Article G, non-interference by any member state in the internal affairs of another is basically a violation of the principles of the Union. So that's a classic idea of sovereignty. Non-interference is prohibited. The next article, Article G, says, the Union shall function in accordance with the following principles. And I quote, the right of the Union to intervene in a member state pursuant to a decision of the Assembly in respect of grave circumstances, namely war crimes, genocide, and crimes against humanity. Okay, let me try and translate broadly. But basically what it means is that African states that have signed that document have permitted intervention by other states into their own affairs if they suffer from crimes against humanity or genocide. So if there's a country in which crimes against humanity or genocide are being committed, and if that country has signed the African Union documents, then it is open for the Assembly of the African Union to say, we are intervening in your country because you have agreed to that intervention. You have agreed to that intervention in a situation of crimes against humanity and genocide and war crimes. We could ask why this extraordinary provision was included. And again, we have to think of the history. And the history has to do, of course, with the Rwanda genocide and so forth. And Africa felt we should take care of our own matters rather than rely on some distant and distant entity which doesn't understand our particular relationships. Okay, so those are just some of the issues I wanted to suggest in terms of the question of human rights and sovereignty. So the basic theme we could say is that there have been a number of developments in various countries which have changed our concept of sovereignty and the relationship between human rights. And these are perhaps issues we should take into account in thinking about this broad question. The final, I'm not sure how many minutes I have. The final regime I want to talk about is a different regime, which seems to be very different, radically different perhaps, and that is the regime of foreign investment law. Now again, the question I would ask is, what is the impact of foreign investment law in terms of the concept of sovereignty? I think I could try and suggest this and illustrate this by giving you an example rather than trying to be too technical. So some of you might have heard about a case being brought by the government of Australia against Philip Morris. So Philip Morris, of course, is a major American multinational, and the sale of tobacco is a principal focus of Philip Morris. Australia, considering carefully all the different issues and approaches to prohibiting smoking, not quite prohibiting smoking, but reducing smoking with the idea of prohibiting it altogether. This is an issue, of course, that certainly affects many countries. Passed legislation which actually required the sellers, Philip Morris, to include plain paper packaging as the vehicle by which it sold its products. I think in Sri Lanka there was a case recently in the Sri Lankan courts, and I believe the case had to do with the government passing a regulation which wanted something like 80% of the cigarette packet to be covered by a warning, in effect, about the dangers of smoking. This case in Australia, after the legislation was passed, was argued by Philip Morris on the basis that the property rights of Philip Morris had been damaged, if not completely destroyed. And the property rights that Philip Morris was talking about, of course, are intellectual property rights. There's a whole discussion to take place about intellectual property and its impact on these types of issues. But the basic argument was, we have lost the value of our asset because of your legislation, and therefore we should be compensated. This case went before the High Court of Australia, which is like the Supreme Court here, the pinnacle court, as it were. And the government of Australia prevailed. And I happened to be in Australia at that time, and there was a general celebration in the newspapers and so forth, because of the fact that the government had prevailed against the cigarette companies. Now, in these cases, nobody, I think, would accuse the High Court of Australia as being a biased socialist communist country. It would be regarded as a civilized country which has a proper rule of law. Now, when it comes to asylum policy, I'm not sure how I feel about that, but anyway, at least in terms of property rights, we could make that argument. What the general public did not realize was that this dispute, even though it was decided by the highest court in Australia, was not finalized, because there was a bilateral investment treaty, an agreement between Hong Kong and Australia. And under the terms of that agreement between Hong Kong and Australia, there was a right provided to any investor whose rights have been allegedly violated to bring this case in an international forum. So Philip Morris said, Australia, we're going to sue you, not in the Australian courts alone, we're going to take you to international arbitration. And so this is how the case has gone before the Permanent Court of Arbitration. So the interesting question is, how should we think of sovereignty when we come to issues of this character? Because the argument would be, it is surely a fundamental aspect of sovereign power to pass legislation designed to protect the fundamental health and well-being of individuals, of their own citizens. That too is sovereignty, isn't it? I mean, we see sovereignty in a very vivid way when people are being blown up by bombs. We feel this is a desecration, people are being killed, we need to do something about it. What about cancer and cigarette smoking? Is that a form of violence that we should recognize and try to protect against? So it's a very interesting thing, this whole question about perceptions, about the different dangers that individual human beings face. When we are subject to terrorist attacks, that seems vivid, and we have to do something about it. When we are subject to these massive advertising campaigns waged by very powerful corporations, which affect not only things like tobacco, but also I believe there's a dispute, or at least a controversy in Sri Lanka about the Food Seed Act, about who would be able to sell seeds, and about the character of the seeds that many farmers find themselves buying, which do not reproduce themselves. I've just been hearing about this from my colleague from the Faculty of Science, who I thought I had to include this information, which I just received this morning. So a further evidence of the fact that I'm learning so much from being here. So Australia, which is a country that has immense resources, has fought this case. Now, here in Sri Lanka, we're concerned about hybrid tribunals and about the interference of foreign judges in decisions that affect the fundamental sovereignty and well-being of the country and its people. And by the way, I'm somebody who makes a distinction between sovereignty in the abstract in terms of government and the sovereignty of the people. I believe that sovereignty rests in the people and not in the government. In this case, then, we could say that what is being interfered with is the sovereignty of the people and the right of a government to protect its own people. Now, what is this tribunal? It's a tribunal consisting of 3 people who nobody would have heard of unless they belong to this peculiar specialized world of international commercial arbitration. So this case is being heard in a different location by a different law with different judges that nobody would really have heard of, except I should say that Australia has the right to select one of those arbitrators. So each arbitral panel in this case, there are 3 arbitrators, one selected by the government, one selected by the corporation, and the other selected by the body which administers the arbitration. Australia has tried to get this case kicked out. The basic Australian argument, and I hope I'm not becoming too technical here, the basic Australian argument is, Philip Morris, you knew that this legislation was going to be passed, and you still invested in Australia. You can't claim that this legislation surprised you. You cannot claim that your legitimate expectations were defeated. Australia has tried to make that argument to make sure that the case does not proceed any further. Just for that one proceeding, Australia alone has spent $50 million. Now, admittedly, these might be Australian dollars, and the Australian dollar has gone down, but at that time, the Australian dollar was pretty much the same as the US dollar. $50 million spent by the government of Australia just defending against one of the first steps in this arbitration. I don't know what the budget of the Attorney General here in Sri Lanka is. I don't know what the education budget is, but imagine spending that amount of money to defend yourself in a situation where you're passing regulations that are designed, and this is Australia we're talking about, that are carefully designed to try and protect the people of your country. So can we see then the paradox about this whole question about hybrid courts and sovereignty? Because Sri Lanka has already signed on to all these agreements which will transfer these disputes from the Sri Lankan courts to these international commercial arbitration bodies. That's what we've done already. Now, of course, we can make a distinction. We could say we have to sign these treaties, these bilateral investment treaties, because if we do not sign these treaties, we will never get the investment that we need for development. And that's very different from a situation where we are fighting a war. So that would be a way of distinguishing between the two, correct? So we might make that distinction, but at the same time, I would go to the point that what is the difference between somebody who is being killed by explosives in the middle of an insurgency and these situations where what people eat and the health regulations surrounding them, what the food that can be grown, all these things are being affected by this new intellectual property regime brought in by the World Trade Organization, which might now be the subject of litigation, not in the local courts, but in the international courts. And of course, this is not merely theoretical because we all have an example. And Sri Lanka has featured very prominently in several of the most important cases relating to bilateral investment treaties. The first of these is a case called Asian Agricultural Products, which took place precisely during the war. So what happened was, in this case, during an army operation in the east, a particular factory was destroyed. The factory owner or the factory characterized itself as English and then used the bilateral investment treaty between England and Sri Lanka to bring a case before a tribunal, an international tribunal, which is basically created by the World Bank. And Sri Lanka lost that case. More recently, all of you, I think, would be familiar with the case that Sri Lanka lost, again, very unfortunately, and that has to do with the hedging deal. So in this case, we had 3 hedging agreements, one with Standard & Chartered, one with Citibank. What was the third? Deutsche Bank. The third was Deutsche Bank. If we have a look at the decisions handed down in those cases, so let me just say, Sri Lanka lost the Standard & Chartered Bank, and the damages against Sri Lanka were assigned as $160 million. This is a case decided by a foreign court, the High Court of England. If we come to the Deutsche Bank case, we have a decision handed down against the government of Sri Lanka, and that decision was again in favor of the corporation to the tune of $60 million. Sri Lanka has lost hundreds of millions of dollars as a result of these proceedings, all of them decided by foreign tribunals. Fortunately, Sri Lanka did actually succeed in the Citibank case, and I believe that decision was the best. I should say that I feel that the law was used badly against Sri Lanka in these particular circumstances, but that's another issue I won't go into. And I would also say that the Sri Lankan lawyers were superb in the efforts that they made to defend the Sri Lankan government in these circumstances. The problem, it seems to me, and I don't know all the background to all this, is that very poor planning took place in terms of the people who entered into these agreements in the first place. So if we look at, I'm getting too technical, but let me just throw out some figures. If we have a look at the Deutsche Bank case, the most Sri Lanka could have expected to receive from Deutsche Bank was $2.5 million. That was the most under the contract that Sri Lanka could have received. What were the losses of Sri Lanka? At the time of the arbitration, those losses were assessed at $60 million. So the best you could make was $2.5 million, and now you find yourself liable for $60 million. The question I would ask is, why did this happen? So what I'm trying to suggest here is that a whole new regime is coming into place, and these are very complex systems of global governance in the mode of international investment treaties. And the work of these arbitrators is quite astonishing. A case was decided by the arbitrators, a decision handed down against Russia for the sum of 50 billion, B for boy, $50 billion. So this is an arbitral tribunal. Now, the interesting thing to note about all this is that even the Western countries, which had previously been trying to promote these investment regimes, even the Western countries are becoming nervous about all this. So what is happening is that the Western countries are reviewing all their treaties to make sure that the treaties include provisions within them that will enable the government to take action in the interests of protecting the sovereignty of its people. The government of India is doing something very similar. The government of India is reviewing all its bilateral investment treaties and has formulated a different model of the Indian bilateral investment treaty, which tries to protect the sovereignty of the people of India. Now, there's another interesting point to be made here. I understand that there's a controversy here not only about the whole question of the United Nations and the hybrid courts, but there's a controversy about the Chinese port. And the interesting question is, what is the impact of the creation of that port on the sovereignty of the people of Sri Lanka? It is difficult to assess, and I don't know whether the documents are publicly available. Are the documents publicly available in terms of the whole character of this arrangement? I think this is something that it would be useful for scholars to have a look at. Environmental scholars, sociologists trying to understand what the social impacts would be, and lawyers. Now, the interesting thing to note is that China, so the question then we have to ask is there a bilateral investment treaty between China and Sri Lanka? Because if there is a bilateral investment treaty between China and Sri Lanka, any dispute about that port project will be heard not in Sri Lanka, it will be heard by international arbitration, whichever body is prescribed there. And it so happens, and I have not been able to do enough research about this because the materials are not easily available, but it is clearly the case that China and Sri Lanka have signed a bilateral investment treaty. They did that in 1986. So I think we have to understand then that already, even though we are so concerned about foreigners interfering with our issues in these types of circumstances, that bilateral investment treaty is going to guarantee, if it is still in operation, I could not assess that, whether the status of the treaty is still valid or whether Sri Lanka has changed its legal regime in that regard. But I simply want to illustrate the point that all these global matters dealing with economics especially are being decided already by international tribunals rather than by national tribunals. In fact, in an Indian case, the actions of the national tribunal were cited as the action that violated the treaty. So this was the case in India, a case called White Industries. The Indian Supreme Court delayed in handing down a decision, and the Australian corporation said, well, that delay itself is an interference with our rights under the bilateral investment treaty. Can we see this? So it is not only the case that the national court does not have decisive power to decide the issue, it is the case that the actions of the national court could itself be the subject of the claim for damages. Can we see that issue? And something happened similarly in the hedging case, because I believe, was it Chandra Jayaratna who tried to bring a case before the Supreme Court? Yeah. And that could have been further evidence of a violation of this treaty. So I think I've gone on long enough already, so let me just try and make a few conclusions. What I've tried to do basically is to complicate this idea about sovereignty, so that we'll think about these issues, hopefully in what is the larger picture, as it were. And let me try and come up with some conclusions. I'm not sure whether there are any clear conclusions to draw up here, but I think I tried to list a few. So the one thing I would suggest is we tend to think of sovereignty very much in political terms, in terms of human rights issues, in terms of criminal justice, and so forth. And that is especially the case now. And I would say that there could be a good reason for that. We should be concerned about those issues. At the same time, what I think we need to understand is the impact of sovereignty when it comes to economic sovereignty. I don't think that is so well understood. When I was kindly invited here about 15 years ago to be involved in curriculum reform, what I found interesting was that there was a huge emphasis on human rights, but there were no courses being taught on foreign investment law or on World Trade Organization law, even though these two regimes have a huge impact on Sri Lanka's economic sovereignty. And by the way, let me say that the University of Colombo has produced two world-class scholars in the field of foreign investment law and international economic law. The first is C.F. Amarasinghe, Dr. C.F. Amarasinghe. who was in Royal at 1948 or 49, who was also a friend of Chris Pinto, who is another outstanding international lawyer. The other great foreign investment lawyer that Sri Lanka has produced, the University of Colombo has produced, is M.S. Saunaraja, who teaches in the National University of Singapore and has just written a superb book which provides a whole criticism of this particular system of foreign investment. But what I want to emphasize here is that even the Western countries are now worried about this. And it's interesting how things change, isn't it? It is now China that is promoting foreign investment agreements. Why? Because it is China that is a foreign investor, whereas previously it used to receive investment. So the world is changing in all these complex ways. So that's one suggestion. Try and understand how economic sovereignty works. It is as important, perhaps, as political sovereignty understood through human rights and so forth. There's another term that I want to introduce here, and that is the term called lawfare. Not warfare, but lawfare. Now, this term has a complex background, but the basic idea is that battles are conducted not through the force of arms, but through the force of law. And the interesting question is, if it is the case that law is a weapon, then how well equipped are we to engage in these battles that we are going to face? That brings me to the third point. And that is one of the issues about globalization is that, unfortunately, what it means is that we are in a state of endless competition. We cannot stand still because all the time throughout the world, including in the area of education, we find ourselves in a situation where universities are competing with each other to do better and better. And of course, it is understandable why, because as Professor Disanayak and others have pointed out, a quality university is essential for the well-being of a people. It is a university that generates knowledge and which provides advice impartially and objectively in situations where there's a lot of uncertainty. So I can't help thinking here of the previous comments made by Ambassador Singh when he said there's a lot of misinformation about the SEPA. And that has a huge political impact. Surely it is the function of scholars who are highly respected in our society to provide an impartial analysis of what SEPA involves. Surely that is an important aspect of the public function of universities. So that's a point I would make there. We can't afford to stand still. This is a system of endless competition. And rankings themselves are an embodiment of that idea. We are either going to progress or we're going to fall in the rankings. And that has an impact in numerous ways that we have to take into account. The other issue, I think the issue of imperialism has been raised in various ways. Imperialism suggests that we should make a distinction between the colonizer and the colonized. And this is a topic that I am interested in, and I've actually written about the issue of imperialism. But I would suggest that in many cases, while we should take that factor into account, it is not the distinction between the colonizer and the colonized alone that we should take into account. The relationship we should take into account is the relationship between rich people and poor people. And what I would suggest about global governance is that we need to understand how powerful forces are changing the structures of global governance, and as all people do, they are changing the structures of global governance to advance their own interests. And I would say that in many cases, even though certain actors might present themselves as nationalist champions, they might also be seen as the rich who are intent simply on being richer and who are participating in a whole process by which their own countries could be plundered in ways that would have a huge impact on the general population of the country. So all I'm trying to suggest is maybe, so my colleague B.S. Chimney talks about what he calls the global transnationalist class, the global elite. And this elite has many different ways of qualifying as the elite. But they are the people in charge, and they would use different labels and rhetorics to justify their power in terms of advancing their own interests. So these are just some of the ideas I wanted to mention here. And it occurs to me I'm supposed to be learned or erudite or whatever it is, but I haven't given you a quotation from some major scholar, some prominent scholar such as, maybe I should have quoted, John Rawls, Martha Nussbaum, But that's too Western, isn't it? Let's become a little more local, sort of Amartya Sen, that would be more acceptable. Perhaps a Nobel Prize winner from India, or maybe something from the Mahabharata, I don't know. But I'm going to quote a Sri Lankan who I find inspiring. I find many Sri Lankans inspiring. Kumar Sangakkara, I just saw him at the hotel last night, and I became like a schoolboy, excited to see this extraordinary Sri Lankan, not just batting out there, but actually like 10 yards, in front of me. I was too shy to ask for a selfie. Everybody else wanted a selfie. And of course, being a wonderful gentleman, he obliged them all. So he is a Sri Lankan I admire greatly. The second Sri Lankan I should mention here is my teacher, Christopher Veeramantri, who you all might have heard of. He's been my inspiration throughout my career. He's an extraordinary man because he is so expert and yet so humble. What is extraordinary about him is that he always treated me, I was just a student. I was his research assistant. He always treated me as an equal. And I can't assess the debt I owe to him. But I'm not even going to quote him. I wrote an article about his latest volume of the autobiography. I'm going to quote another Sri Lankan whom I find quite inspiring, and that is Sunil Pereira. Why do I find Sunil Pereira inspiring? I think his quotation should be the motto that governs us all. I don't know why. I think this is the motto that any academic should actually embrace. Because however much we know, there's almost always so much more that we don't know. I don't know. And why? Why is the fundamental question that animates further inquiry into a particular phenomenon. I'm sure now that I think about it, I could perhaps write an article about the relationship between Sunil Pereira, I don't know why, and the Socratic method. Because the Socratic method is also about advancing knowledge through the process of questioning. And maybe that's Buddhism as well, I don't know. So, to exemplify what I said. So, thank you for including me at this very crucial juncture of Sri Lanka's history. You must be tired of all these foreign experts coming here and telling you what to do. So I'm not completely a foreigner, nor am I particularly an expert. But one thing that strikes me, which I feel I should mention for whatever it's worth, is that Sri Lanka, which is a country of such beauty, a country which has produced so many talented people. One thing I want to emphasize here is I've taught all over the world now, pretty much. I haven't been to South America. I'm hoping to do that soon. But Sri Lankans are as talented as anybody else in terms of the actual potential of the students that come through the Sri Lankan system. I don't know how that survives, frankly. I don't know. I don't know how it survives, given that the country has been through so much social trauma. And yet it seems to be an integral part of the culture of Sri Lanka that education is valued extraordinarily highly. And we know this, isn't it? Because we can see people selling their houses to try and send their children overseas. The poorest people, fishermen, trying to scrape together the money that would pay for tuition classes. So in the midst of all this, it seems to me tragic that we have not, dare I say this, fulfilled our potential. And again, I don't know why. But all I can say here is that in terms of all the issues about commissions and inquiries and so forth, I think we have to try and understand the truth of the situation without any fear. Because if we don't understand the truth of Sri Lanka's post-colonial history, I'm afraid that we will repeat the same patterns. You might have seen this film called Apocalypto. It's a Mel Gibson movie, and it's about the savage conduct of the Aztecs or whoever it is who sacrifice all these people, kill them in the most violent ways. And these are just sacrifices that are made without any meaning. If we think of the post-colonial history of Sri Lanka, I've come to a rough rule that every 20 years or so, 100,000 people are killed in very violent circumstances. So we have the 1971 emergency, I would say 100,000 or perhaps more. We have 1989, 1990, another 100,000 or so. And we have had the ongoing issue of a civil war. So in the midst of all this, surely we need to actually try and understand our own situation as best we can. So that is all I hope that we will be able to achieve. whatever the process that takes place, and to make sure that people who feel that injustices have been done to them are people who can be convinced that their concerns are properly and legally addressed. That is my general hope and my general ambition. As I said, I think we're all very fortunate. And I feel, again, having traveled to many places, that the respect that the people of Sri Lanka extend to their teachers is extraordinary. So when somebody says in another country, I worship my teacher, they do not mean it literally. In Sri Lanka, students literally worship their teachers. I was very touched, even in Australia, when I was studying there, one of my Sri Lankan friends wanted me to come and teach his son how to write. There's a whole tradition here about the importance of education and so forth, and we all enjoy a very special status as a result of this culture that favors education. We are in a very special position. And I hope we can meet the responsibilities which come with that privilege. It's the rule from Spider-Man. With great power comes great responsibility. With great status and reputation comes great responsibility to our students and to our universities and to our country more broadly. And I'm glad to see that this particular forum has shown a lot in terms of what all of you are doing to fulfill these responsibilities. And yet I feel all of us must strive for more. And so these are the parting words I leave with. And let me thank you once again for being kind enough to invite me here, and also for being kind enough to endure my ongoing rantings about all these issues. Thanks very much.